Hi there, I'm Tshepo Fokane, the Acting National Coordinator for the Alliance for Rural Democracy. So today, 5 June, marks 5 years since our historic march to the Union buildings, where we handed over a memorandum to the Office of the Presidency, asking that President Ramaphosa does not sign the traditional and Khoisan leadership bill into law. Fast forward, and obviously, the Traditional and Khoisan Leadership Act was in fact signed into law. And in February 2023, we argued with our lawyers, the Legal Resources Center, in the Constitutional Court that we felt the way that Parliament introduced this law was really worrying. The processes of meaningful public participation we thought were really lacking, especially because we had traveled all over the country, visiting and joining in the public hearings throughout, whether convened by the National Assembly or by the NCOP. And what we realized is that the voices of the most affected people weren't really making it into the final law. Ultimately, what is it that we stood against for the Traditional and Khoisan Leadership Bill? It was Clause 24, amongst others, that allows traditional leaders to enter into deals and negotiations with a third party on behalf of the community. What that means is the community has the right to be consulted, but not ultimately the right to consent. And this really goes against our beliefs in free, prior, and informed consent, the right to say no, and the right to say yes, because we strongly believe that for participatory decision-making to succeed, rural communities have to have a greater say in land deals, investments, and natural resource governance, because they're ultimately the custodians of the land. And what made us march in 2019 was that we felt really strongly that our voices were not being heard. And we wanted to appeal to the president to say, number one, we 100% support the statutory recognition for the Khoi, Nama, San, Khoisan, and other subgroups, which had never been done before. And number two, we were really worried that a law like the TKLA would just rubber stamp the practices happening already, where your rights in rural spaces in terms of land and decision-making get trampled on, because ultimately the voices that seem to carry more weight come from traditional authorities. We were also really worried about the clause that looks at creating these D accounts. That's a development account to hold royalties, revenue, earnings on behalf of the community. We're worried because we've seen what happened in the Northwest, where their development account for several communities didn't actually ever get audited. What that meant is that monies couldn't be traced, couldn't be found, and communities that live on really mineral-rich lands are still poor to this day, in spite of being the owners of this land. Added to that, there's another layer of complexity where there's a lot of land claims that are not yet finalized. And we know that June is also the month where we commemorate the signing of the 1913 Land Act, which ultimately dispossessed Black South Africans and confined us to live in the 13%. This was possible through subsequent laws that then created the Bantustans. And so at the ARD, when we say stop the Bantustans, we mean all of the practices that discriminate in other rural people, all of the ways that rural people's voices don't seem to carry the same weight as people living in urban centers. This could be through things like traditional courts. This could be through mining laws and policies. This could be through anything really that relates to our land, our customs, our practices, our traditions, indigenous knowledge. The list is endless. And we were saying, and we continue to say, even today, 5 years on, stop the Bantustans. Join our campaign, support us, stand with us, and continue to listen and uplift rural voices. Thank you.